Thanks, Maggie. Thank you for having me. I'm very excited. Unfortunately, these days, there's a lot of uncertainty in the workplace, and this became incredibly apparent when, you know, these days everybody has to share a workspace, even me. So I'm currently sharing a workspace, and I'm just gonna ask, hold on one second. Excuse me, can you just keep the sound down? I apologize. Okay, so everyone has to share a workspace. There's a lot of uncertainty, as you can see here. And so I'm hoping today to go through some of those uncertainties and common questions that we've gotten since, March, when my firm everybody started working from home, along with a lot of people in New York. And so hopefully I could provide some certainty and provide some answers to some of the common questions that people have and some of the rights and benefits that you have in the workplace. Here's my number will be at the bottom of the screen, and of course, if you have any questions during the presentation, you could always send an email to Maggie or ask the question in the chat. But of course, you can also shoot me an email, and I'd be happy to talk to you at a later time if you have any questions that you need answered that you don't want to necessarily have answered publicly. Okay, so very important. Today we will be addressing some common employment rights and issues. This is just going to be general information, and it's not intended to be a personalized legal advice. And the reason I say this is because there are federal laws, state laws, city laws, even smaller municipalities have special laws. So while sometimes I'm going to identify whether something's a federal law that would apply to anybody in the United States, I'm not necessarily always going to be parsing the difference between a federal law and a state law. This presentation will obviously be a little bit more New York centric. That's where I practice. There are a couple of tidbits about New Jersey that I might add in, because I'm also admitted in New Jersey, and we get questions about New York and New Jersey all the time. But if you have any specific question about your own personalized situation, please definitely, you could shoot me a message after the presentation. I'd be happy to speak with you about it. Okay, so here are some of the common concerns, and I've been giving this presentation for a little bit now, and it's interesting how the concerns kind of shifted over time. So in the beginning, they were, a non-essential worker might call up and say that their boss is requiring them to come into work, or an essential worker, who has COVID-19 and the boss is pressuring them to come into work. But and another common one is issues with school care, and if you have a child that's no longer able to go to their school because the school closed because of COVID-19, which I'm sure a lot of people are in that scenario, in that situation. What happens? I mean, what if just your productivity is lower? What rights do you have? But those questions have shifted recently to my company is now reopening, and what rights do I have? I'm a little bit nervous about going back to work. Am I allowed to say no? I want to go on a vacation. I have a home in Florida, or I want to go to Florida. Am I allowed to go to Florida? And then I come back and I'm required to quarantine for 14 days. How does that impact my my employment rights and benefits? So the place that you could go for answers, the internet. I found the internet to be actually quite a good source for information, and especially the Department of Labor's website, federal and state. The only problem is that I wouldn't bet my entire job and livelihood on it. And so while you can go to the internet for some basic information first to start, that's good, but again, I wouldn't bet my job on it. The Department of Labor is another good resource. The only problem is you can't get through to the Department of Labor. I did hear that you can call up at 8:49 because the phone line's open at 8:50, and then you might be able to get through, but overall, my clients have told me that contacting the Department of Labor has been very difficult. And of course, you could consult an attorney. A lot of employment attorneys that represent employees do free consultations, or are just happy to give advice in general, especially these days where there's so many people calling up with the same or similar questions about how a certain situation relating to COVID-19 has impacted their ability to work. So the first thing that we all have to understand before we get into this is that we live in a system called an employment at will system, and what that means is basically while you have a right to leave work, whenever you want. Your employer has a right to fire you or basically change your job description whenever they want to, and for any reason or for no reason at all, with very limited exceptions. Those exceptions are if you entered into a contract that says that you're going to be doing this work and for a year or for a particular amount of time, and you cannot get fired unless you do something that is called for cause, meaning there's a reason that you deserve to be fired. If that's the case, then you actually have a right to your employment, a contractual right. If there's a law that prohibits the firing, so for instance, you're not allowed to fire, demote, or change someone's working conditions based on certain discriminatory bases, for instance, the color of a person's skin, their religion, national origin, disability, things like that. And especially with disability and COVID-19, we'll get into that shortly. But that's a big protection that may apply to you. And the last is you're not allowed to be terminated for refusing to do an illegal act. So let's just say you are an essential worker. Excuse me. Let's just say you are a non-essential worker, and your company is not allowed to open up. If your company says you are required to show up to work, you can refuse. And of course, if your employer fires you, you would have something called a wrongful termination. You would have the right to bring a wrongful termination lawsuit or action. Okay, so the first subject that I'm going to be addressing is workplace leave. So prior to COVID-19, there's the Family Medical Leave Act. This is a federal law that basically provides 12 weeks of unpaid leave to job-protected leave in certain situations. If you have a serious health condition, including a flu would not normally count, but if there were complications, it would count. So it could be that COVID-19 has been sort of considered to be the flu, but generally on that level, except that if you have complications, you have to go to the hospital. That would be tantamount or equal to the flu with complications. If you have to care for an immediate family member with a serious health condition and to bond with a newborn, including adoptions. So you could get 12 weeks over the course of a year for that, and you're eligible for it if you are employed for 12 months and within that time period, over more than 1,250 hours. In addition, the company has to have more than 50 employees. So otherwise, you're not going to be eligible for this unpaid leave. After coronavirus, the federal law enacted the Family First Corona Response Act, the FFCRA. The FFCRA, you only have to be employed for more than 30 days with the company, but the company has to have under 500 employees. So if you work for Walmart, this would not apply to you. It provides paid job-protected leave in certain circumstances, and that basically if you are quarantined or self-quarantined and seeking a medical diagnosis. So let's just say you think you might have, you're displaying some symptoms of COVID-19. You can't just self-quarantine and decide that you're entitled to paid leave. You actually have to take some affirmative steps to get diagnosed. And so I would recommend, of course, getting tested. And during that time period, you would be entitled to paid leave. If you're caring for an immediate family member in that same situation, and if your child care is unavailable due to unpaid leave. What's interesting about the child care issue is that until recently, all schools were closed. So if you have a child who's school age and is required to go to school, meaning they're through high school, then of course you need to. It's understood that your child was going to go to school, but now school is over, and so the question is whether if your child is home now in the summer, how do you show that they were going to go to camp? If you were going to be sending your child away to a camp, but now that camp is not open, that would also qualify you for this paid leave. But not every child goes to camp in the same way that every child goes to school. And so my recommendation would be, of course, if your child was enrolled, of course, that's perfect proof. But, some programs that you send your kid to every year may not have even opened, there may not have even been an application process. So you have to have some sort of proof to show that your child was going to go to camp in order to establish your entitlement to the paid leave. And that would basically be in the form of showing that your child has gone to this camp in years past. That would be it's a case-by-case basis, but that is typically sufficient. Normally, it's only about 2 weeks of paid leave for the first two situations, the quarantines. But if it's an issue with childcare, then you get an additional 10 weeks, and so that's 12 weeks total. New York State also has its own paid leave called paid family leave, and so unlike the regular standard Family Medical Leave Act leave, you have this is paid leave. So if you are taking maternity leave or paternity leave, you can take off in 2020. You can take up to 10 weeks of paid leave. In 2021, it'll be 12 weeks of paid leave. An employer is prohibited from requiring an employee to use sick leave or paid time off for COVID quarantine order. So for a COVID-19 quarantine order. So if you are diagnosed with COVID-19, then your employer can't say, okay, well, you have to take your paid vacation days first. No, you're allowed to take the paid family leave and hold on to your paid vacation days. However, the New York paid family leave does not cover school closures, unlike the federal law. But there are certain other protected rights under New York State law, and that's called protections under familial status and caregiver status. These are very similar, but familial status and caregiver status means you cannot be discriminated against on the basis of having children or family. That's familial. And caregiver is on the basis of having to care for, if you're the primary caregiver for somebody. So that does not necessarily mean just a child. It could also mean somebody else in your household. It could mean somebody who's elderly if you need to care for them, or if you have an ill spouse or anybody else that lives with you and you need to care for them and take off from work. So you're not allowed to be discriminated against. However, employers are not required to provide you with special accommodations for this. Unlike with disabilities, and we'll get to that in 1 second, but with disabilities you get special accommodations. So for instance, if you have a disability, you need to be off from work for a week, your employer is required to give you that week off. However, here, your employer is not required to give you a week off for caregiver responsibilities or familial responsibilities. However, you have to be on equal footing with other permitted leave. So let's just say somebody wants to take a week off to go play golf, and an employer allows them to take that week off to go play golf. An employer is not allowed to then deny a requested leave on the grounds that you have caregiver responsibilities. It has to be treated equally with other leave requests. Okay, disability discrimination and its impact with interplay with COVID-19. I put an exclamation point next to disability, not because we are celebrating necessarily disabilities, but when you are deemed disabled under the law, that provides you with the access to these rights and benefits, and so it's a good thing under federal law. Like I said before, COVID-19 is sort of on the same plane as the flu and is not considered immediately a disability. It really depends on whether you are displaying certain complications when you have COVID-19. People with disabilities have rights. For instance, you are protected. An employer is not allowed to make employment decisions on the basis of the disability. An employee is entitled to a reasonable accommodation, but of course not entitled to all accommodations. So if you want one accommodation and your employer wants to provide you with a different accommodation, so long as the employer's accommodation is reasonable, then that's the one that you're stuck with. The employee is required to, has to be able to do the job with or without this accommodation. So if, let's just say, for instance, I'll give you an example in a moment. Let's just say you're applying for a job and the employer needs you to work immediately. On Monday morning, you apply on Sunday, you get the job, you need to start working on Monday, and the employer really needs you to work that day. If you contract COVID-19 and therefore not allowed to work on Monday, or you physically cannot work on Monday, there's no accommodation that can be given to you that would allow you to necessarily work. And so the employer, because the employer needs you to work that day, the employer would not be required to give you the job. However, in order for the employer to say that it does not need you to work that day, the employer would have to show that it's something called an undue burden. Undue burden means impose a significant difficulty or expense. So let's just say that Monday morning, the employer needed you to deliver something that was due that day, and you're a delivery person, and you couldn't make the delivery, then that would be an undue burden, because the delivery has to be done that day for the business, and so the employer would be allowed to go find somebody else and replace you. However, if the employer just needs something that's done that day because they want something done that day, but it could really get done in 2 weeks or 3 weeks, that would not be an undue burden. So the other problem with COVID-19 being considered a disability is that COVID-19 is also a pandemic and highly contagious. And so it falls under this category of something called a direct threat, meaning it could create an environment within the workplace that is dangerous and is a direct threat to other people around you. And so because of that, employers have a little bit more leeway in what they can do. Unlike with many, many other disabilities, they cannot do a lot of these things. So for instance, let's just say you have COVID-19 and the employer finds out. An employer is allowed to tell other coworkers that somebody has COVID-19. They're not allowed to disclose who it is, but they're allowed to disclose for matters of public safety that the coworkers might have been exposed to this. That would not normally be allowed. Let's just say you disclose to your employer that you have a disability, and your employer is not allowed to disclose to other people that, oh, there's somebody in the office that has this disability. An employer is allowed to require employees to undergo medical examinations in preparation for employment. The only note about this is that it has to be done equally. You're not allowed to discriminate on the basis. You're not allowed to make only Chinese applicants go through medical examinations. That would be discriminatory policy. But if you have a policy that applies to the entire workforce and is not discriminatory, then you would be allowed to have them a pre-employment medical examination. You're allowed to ask if your employees are experiencing COVID symptoms. You're allowed to require your employees to undergo temperature checks each day. You're allowed to require employees to wear PPE, but note, of course, that if you require employees to wear gloves and you provide them with gloves, if those gloves are latex and you might have somebody in in your workforce that has a latex allergy, then that would not be permitted. That person would need a reasonable accommodation, which of course would mean that you got to get that individual non-latex gloves. You're allowed, somebody who is displaying symptoms of COVID-19 is allowed to be sent home. And the example I gave before is that you're allowed to delay the start date for a new hire or withdraw a job offer if you need someone to start immediately. What employers cannot do. They're not allowed to force an employee to take an antibody test. The EEOC, the Equal Employment Opportunity Commission, essentially ruled that antibody tests bear no rational relationship to the workplace, and so knowing that information isn't going to help any job necessarily. Of course, if there was a real business reason that an employer had to get an antibody test of its employees, it would be allowed to request that. Any cost that is imposed on a mandatory test has to be paid for by the employer. An employer is allowed to rescind the job offer or send an employee home due to medical, they're not allowed to rescind a job offer or send an employee home because they're trying to protect an employee. So let's just say you are pregnant, or let's just say you are over 65 and so you have a higher risk of complications, or you have a disability which would give you a higher risk of COVID-19 complications. An employer is not allowed to say, well, for your benefit, you have to stay home. That's not something the employer is allowed to do, and the employer is not allowed to ask whether you are pregnant or how old you are, or whether you have a disability, an underlying disability that would create COVID-19 complications. But let's just say you do have a complication, or you are nervous about going back into work because you have an underlying condition, or you're pregnant, or you're over the age of 65, then you can ask for a reasonable accommodation from your employer, and your employer would have to give it to you. Again, it has to be reasonable, and it cannot be an undue burden or expense on your employer. But your employer, there would have to be, at the very least, a conversation about it. But note that employers are not required to give a reasonable accommodation if somebody in your household is at a higher risk of COVID complications. Although I would suggest anyone who has a company out there, I would highly, highly suggest being reasonable about this and having a conversation with the employee about trying to find an accommodation for that employee to work from home if they do have somebody who may have COVID-19 complications. So going back to reviewing your rights, if you're a non-essential worker, can your boss make you come into work? Of course not. That would be a violation of the stay-at-home orders, and so the employer is not allowed to do that. Let's just say, well, let's get these all up there. Okay, let's just say you are an essential worker, and you think you have COVID-19, but your boss is pressuring you to come to work anyways. You know, as long as you're seeking a medical diagnosis, then you are allowed to. As long as you're actively seeking a medical diagnosis, then you're entitled to stay home. Okay, how to protect yourself? Know the law. Like I said before, you know, read up on the internet, but don't bet your job on it. You could consult with attorneys. You could call the Department of Labor. But the last two are very important. Preserving documents. If you feel like you're being discriminated against, oftentimes there's a he said, she said, and obtaining documents from an employer is very difficult because they're understandably unwilling to provide the information that you need if it's bad for them. They're not going to provide it, and then it causes a mess. So it's incumbent on everybody now to try to just jot down. If you feel like you're being discriminated against, just go write in a notebook the date, the time, who was around, and the potential witnesses, and if you have any emails, you should save them, and exactly what happened. And that recording will save you later down the road if you need to do something about it. Okay, let's try to tackle some unemployment insurance benefits as quickly as possible. Here we go. Okay, there's two different types of unemployment. There's your standard New York State unemployment insurance benefits, and then there's something called the pandemic unemployment benefits. There are a couple different pandemic unemployment programs, and there was actually recently an extension that was done to the pandemic unemployment benefit program. If you're not sure if you qualify, apply. That's the rule. Don't lie, apply. Because if you lie, you're lying on a government form, and there's a pretty severe penalty for that. So do not lie, but you can apply and let them decide whether you are eligible or not. And there are plenty of people that I know that did not think they were eligible. They applied, and now they are getting unemployment benefits. Your standard unemployment, you have to have a prior work and pay history of a certain amount of time over an 18-month period. You have to lose your job through no fault of your own, meaning you cannot quit, you cannot get fired for a legitimate reason. You have to be ready, willing, and able to work and actively seeking work. However, you could be working part-time and still entitled to unemployment, and that is so long as you're working less than 4 days per week and you are earning under $504 per week. And the benefits for standard unemployment is up to $504 per week for a 26-week period. This was modified by pandemic unemployment benefits. So let's just say you lost your job due to COVID-19, and you don't need the prior you do not need the prior work and pay history. It applies to gig workers, freelance workers. The only people it does not apply to are teleworkers and to those who are receiving other benefits like sick leave or paid benefits. The advantage is that let's just say you do not you're not eligible for regular New York State unemployment. You could still be eligible for pandemic unemployment benefits. And Those benefits are the New York State standard unemployment. So you'd be getting $504 per week, or up to $504 per week for 26 weeks, plus an additional 13 weeks, which is the benefit that is provided by this pandemic unemployment assistance, plus an additional $600. So you could be getting 2 checks, one a check for the New York State unemployment, a $600 check, and you'd be getting that for 39 weeks. The only problem is that the $600 check, the extra $600 payment, ends July 31st unless it's extended. There is an extension program, but not for the $600. There's an extension program under the federal program. The extension is for up to 46 weeks as opposed to 39, and under the New York State program, it's up to 59 weeks now. If you are eligible for New York State unemployment, you could get it for up to 59 weeks. The qualifications for pandemic unemployment assistance is that you have to be ineligible for regular New York State unemployment, and you have to lose your job or not have your job due to COVID-19. So you're either diagnosed with COVID-19, or you're caring for someone with COVID-19, or you can't work because of childcare responsibilities. You're unable to reach your work due to COVID-19, things like that. The other way to get the $600 a week is instead, not just through this pandemic unemployment assistance. The other way to do it is if you qualify for regular standard New York State unemployment. So if you are qualified for regular New York State unemployment, you also are entitled to the extra $600 a week. But like I said, that ends July 31st. Okay, so how do you apply? You have to create a New York.gov ID account. You do it through the Department of Labor website, and you need certain information: your social security number, driver's license or ID card, name and addresses of all your employers for the past 18 months, and a W-2 form. And I highly, highly recommend having even pay stubs and other documents readily available to you. And if you have everything ready to go, if you could get it done in 15 minutes. If you don't, it could take an hour. Okay. I hope that this has been informative, and I'm absolutely happy to answer any questions now if anybody has any.
Okay, great. Thanks, Jack. I will remind everyone, if you have a question, you can use the chat box, or you can email info@savvyladies.org. And the first question for you is asking if a person works in an elementary school for a food service company starting in August when school is potentially back in session. What are a person's rights with potential unemployment benefits or paid leave if you're uncomfortable working in that environment due to COVID-19?
Okay, so that was like two different questions wrapped in one. So let's just say, just to clarify, one is what are your unemployment insurance benefits, and the other is about going back to school, or going back to the school or the work environment in September?
Yeah, starting in August, and then potential unemployment benefits or paid leave. Okay.
So when it comes to schools, it's a little bit different because if you work at a school, you're always off during the summer unless you have a different job. And so unemployment, people who work for a school are typically only eligible for unemployment if they are not expected to go back in September, or if they're getting paid throughout the summer. But if they are expected to go back in September, then you're not entitled to unemployment over the summer, based on just that general situation. There might be other factors that can go into whether you're entitled to unemployment, but generally, if you are going to be going back to work in September, then and you're not getting paid over the summer, then you are entitled to unemployment. And then if you are nervous, and then about being nervous about going back in September, well, your rights and your leave benefit rights depend entirely on the reason. If you have an underlying condition, if you have COVID, or if you're seeking treatment, or let's just say you have somebody in your household that you need to care for, it will depend largely on that. But typically, unless you can't just say that you're nervous about going back, that's not enough. The anxiety is not necessarily enough to entitle you to any leave benefits.
Okay. Thanks, Jack. Next question is saying, my employer suggested I resign when I told them I wasn't comfortable with the accommodations at work. I have been working for a week and still don't feel safe. If I decide to resign, would I qualify for unemployment benefits?
You could, and this is a perfect situation of where I would say somebody should apply, because it's you are basically resigning because of COVID-19. And so this puts you, normally if you resign, you're not entitled to New York State unemployment, but if you resign because of COVID-19, you could be entitled to pandemic unemployment assistance. Now, even though the $600 a week only ends on July 31st, pandemic unemployment assistance also gets you the regular New York State unemployment amount. And so that goes through December, as of now, it goes through December 31st, 2020, and you can get up to 46 weeks of that. So I would highly recommend applying either way. Whether you are entitled to it, it depends on what the accommodations are. It depends on the accommodations at work. It could be that your employer is engaged in some sort of OSHA violation. And if that's the case, then your resignation would be called a constructive discharge, meaning it's not that you're actually resigning, it's that you are forced to resign because of the employer's activities, in which case you would be entitled to even New York State unemployment. But I would recommend applying.
Okay, thank you. Next question is asking if you have to prove citizenship to get any or all of the benefits.
Yes, you will. You need or an alien ID number in order to get the benefits. You have to be working here legally. You don't necessarily have to be a citizen.
Okay, thanks for clarifying that. Next question is saying that my daughter can't work at the summer camp where she's worked the last few summers because they're closed this summer. Do you think she can claim unemployment or lost wages for that summer job?
Yeah, she should definitely apply, especially for when it comes to pandemic unemployment assistance. She should apply for that. New York State, if she's a student, that she might not qualify for New York State unemployment because she may not meet the prior work or prior wage requirements that are necessary over an 18-month period in order to qualify for seasonal unemployment. But certainly if she's working there, in prior years, she should apply because she may be eligible for the pandemic unemployment assistance or for the summer.
Okay. A follow-up to the previous question is asking if I don't have a driving license, what's the alternative?
That's a good question. I'm not entirely sure. I would think any sort of any New York ID would work, or more or less any ID would work, I would think. And what the problem is that the Department of Labor system for online system for applying for unemployment is very limited. And so if you have a situation where there's some sort of questionable answer, you can end up having to call them and talking to them, which then the application process gets extended. So if you don't have an ID, then that might be the scenario, but I'm not entirely sure. I can look it up, I'm happy if you want to email me. I'd be happy to look it up for you and get back to you.
Okay, great. And we will share Jack's email and contact information that's here on the slide. We'll include that in the follow-up email if anyone wants to follow up with questions. Jack, the next question is asking if school doesn't start, must work accommodate, or is there leave available because kids are home and homeschooling?
Oh, if school doesn't start, I don't know. It'd just be terrible. That would be bad in and of itself. If school doesn't start, then it depends. Because you're only entitled to, under the federal act, you're only entitled to 12 weeks. So if you've exhausted those 12 weeks, then your employer is not necessarily under the federal law required to give you any additional time. Under New York State law, you have caregiver responsibilities and familial responsibilities, and so what that it could be that an employer is required to provide you with equal accommodations to someone who's making a different type of request in the workplace for leave. But let's just say you have an employer who you've exhausted your other benefits and you've exhausted your New York paid leave as well. Let's just say this doesn't relate to childcare, but if somebody's sick in your household, if you've exhausted all your benefits and your employer's the type of company that doesn't provide any additional time off to anybody, no matter what, then you're not going to be entitled to any sort of protection.
Mm-hmm. Okay. Jack, it looks like we have 2 more questions. Do you have time for 2 more?
As many as there are. I'm here all day.
Okay. This one is asking if there are additional benefits if you have family commitments.
Well, I guess it depends on what those commitments are. Very much so. If you're responsible for caring for somebody, then you can then you'd be entitled to leave benefits. But under the different laws, so long as you haven't exhausted them. But it depends on what your commitments are. If your commitment is to having to go shopping once a week, then I don't think that would qualify.
Mm-hmm. Okay. This question is asking, I'm new to work for a school district that seems to be headed for full-time and full capacity school in the fall. There's a chance that the district will not require students and staff to wear masks. I have a history of asthma and am in close contact with students, parents, etc. Is there any protection for me if I need to take precautions or if I feel I can't be safe?
Yes, absolutely. Your employer asthma is a disability, especially under the law, and especially these days. And so your employer would have, if your employer doesn't know about it, then you should reach out to them, let them know that you have this underlying disability and that you want to discuss reasonable accommodations. It depends what you do at the school. If you're a teacher and they're doing the problem becomes is what accommodation can they provide to you that's reasonable if everybody is learning from school. But again, that depends on your school and the situation. But you would have at the very least a right to a conversation about what reasonable accommodations they can provide to you, including paid time off. And you would also be entitled to certain leave as well. Not necessarily paid leave, but certainly certain leave.
Okay. I just saw a follow-up to this question is I'm a therapist and I travel to several different buildings.
Okay.
So that's in the school.
Yeah, absolutely. I know that some schools have, I know that billing is, when it comes to billing for certain therapies, I know that there's all these complications. And so it's going to depend on that. But let's just say you're allowed to bill for telehealth. And you've been billing for telehealth, and that's how it's been this entire time. And then the school year starts. I would think it would be a reasonable accommodation to allow you to continue doing teleappointments. But if your job really does require you to come into the school and to work directly with the students, then they might be required to provide you with a face shield or a mask, or require anyone that goes into your office to wear a mask or a face shield and provide that to them. I would definitely be, if you want to, feel free to contact me again afterwards, and we could go through other types of potential reasonable accommodations that you can ask for during this conversation.
Mm-hmm. Okay. And Jack, we do have some more questions. Thanks for offering to take these. So the next one is asking if the COVID leave is paid.
COVID, well, it depends which. Yes, yes, it is paid. I'm not sure exactly which one you're referring to, but if you qualify for the federal leave, then it's paid. If you qualify for the New York State leave, then it's paid as well. So yeah, it's paid. Only for a certain time, obviously, but yes.
Okay, and this is another question, but also related to paid leave. If you have paid leave due, is the employer obligated to provide this if you're getting benefits as well due to COVID?
Meaning if your employer is already providing you COVID-specific benefits, then you would not be entitled to both. You would just get one.
Okay. Okay, thanks. And Jack, the last question for you is asking, how would I determine when it's necessary to hire an attorney, and just kind of wondering what that would look like. So for someone who's thinking about it and not quite sure, could you maybe just walk us through what that looks like?
Yeah, absolutely. My pleasure. My recommendation is that there's no, especially if you have an employment issue, there's no cost in calling an attorney to speak to them, to pick their brain. You could call more than one attorney. You can also, and this is what I recommend to my clients, especially if I think that they are, if their claim's not worth all that much money, you got to think about whether this is best for you. Because typically when you file a lawsuit against your company, they're not going to take kindly to that. If you request something from your company forcibly with a lawyer, they're not going to take kindly to that. And even though retaliation is unlawful, that doesn't mean it won't happen. And so you need to, lawsuits take a long time. And so, you know, if your employer is going to fire you for raising this issue, and you're not going to have a job afterwards, then you have to weigh that against, you know, a couple of years in getting justice. And so what I recommend in these situations is talk to somebody that you trust that's not the lawyer. You know, you could trust me, but but obviously you should talk to somebody who you trust, like you would do in any other situation, in any other life circumstance. So long as you don't think that you're just going to get swindled on the phone talking to a lawyer, I highly recommend calling up plaintiff side, employee side lawyers just to pick their brain and get information, which a lot of, certainly at my firm and a lot of other firms that I know of, they'll do that.
Okay. Jack, there was a question asking if people can email you about their personal situation, and so I just wanted to confirm with you that that's okay to direct people to email you.
Absolutely, and every email is privileged and confidential. It doesn't go anywhere, even if we don't have an agreement, even if and it's all free. So, yes, absolutely.
Okay. All right, great. So we will send Jack's contact information in our follow-up email soon. So I want to thank you, Jack, for a really great presentation, and thank you so much for taking the time to answer all of these questions today. You clearly are a wealth of knowledge, and thanks for taking the time to explain everything to us today. So thanks, everyone, for joining us today, and we wish you good luck.
Bye, everybody.
Thanks. Bye-bye.